Hello, good morning, everybody. How is your day going? You're welcome to Legal Clues on Emirate Radio. Of course, on Legal Clues, we give you legal tips that you need to be aware of to help you to make informed legal decisions. We bring you closer to your laws. We make you abreast of those things that you should know to help you to live a crime-free life. My name is Damilola Obadimeji, your host on this program. And as you know, on Legal Clues, we usually try to discuss legal topics that will inform everyone listening to us. On today's episode, we'll be discussing writing of your will. It is very important to, make sure you put your will into writing. First and foremost, what is a will? Simply put, a will is a document made by a person we call a testator, stating how he wishes his assets or his estate distributed after his demise. We all know that death is inevitable, but there are a lot of misconceptions about will. Some people assume that you should only write a will when you're about to die, probably when you're sick and you're bedridden and you're almost, dying. You should put your will together and write. No. A lot of people also think that, will should be written by elderly people who are old. That is not the case. Will is not a death sentence. It's only a way of preparing yourself to make sure that your loved ones are well catered for after your demise. So like I said, a will is a testamentary disposition that usually help a testator to give instructions to his executors on how he wishes his or her assets distributed after his demise. So simply put, a will is just a document that enables you to state how you want your assets to be distributed. It helps you to state who you want to have this, who you want to have that, of all your beneficiaries. Writing your will does not mean that you are going to die soon. It doesn't mean that you are old already. It's just that you are planning for how you want how you want your family or the life of your loved ones to be after you have probably died. Planning for, how it should be after your demise might be a bit uncomfortable. You might feel, I'm planning for how, after my death, what will happen. But it's a relief. There's a relief that you have when you know that those you leave behind will be well catered for. And there are a lot of benefits attached to writing your will. There's so many advantages attached to writing your will. The first one is it helps you to decide who gets what among your beneficiaries or your loved ones. Who gets your estate. It helps you to decide that you want to give this to this particular person. It helps you to decide that I don't want this person to have this in my estate. It helps you to decide, I love this my aunt. I want my aunt to have this out of the things of my estate. It helps you to determine a lot of things as to how you share your properties after your demise. Not having a will mean that you die intestate when the person dies. It will only leave the people you leave behind, your loved ones, to not be going through the hassles of, applying for a letter of administration to be able to administer your estate and the likes of it. But once you already have a will in place, it makes everything easier for your loved ones. It helps you to decide who take care of your minors in some instances. There are situations where people have minor children, small children that are not up to the age of accountability yet. In a will, you can definitely appoint guardians for your minor children. That is part of the advantages of a will. It helps you to prepare towards that. If you die today and your children are still very small, you appoint this person as a guardian for your children, who will in turn take care of your children as you would have instructed the person. And it helps you to go to your grave with this settled mind that nothing's going to be nothing wrong will happen to your children. It helps you also, and one of the advantages of a will is that it helps you to facilitate the probate processes. For example, there are a lot of things that can happen. Maybe after your demise, you have so many things to benefit from. Let's say your office, for example. And you know that they're not just going to release your entitlement to anybody just like that. It's either they produce a will that you have written stating that my entitlement should go to this person out of my loved ones, or they produce a letter of administration where there is no will, that they probably would have gone to probate registry in the high court of their state to facilitate it and bring it to the office. They don't just release your entitlement like that. So wills help you to make probate processes faster. It doesn't delay things. It's always lengthy and difficult if there's no will and you have to start processing letter of administration. It can even take months. But when you have a will in place, it makes everything faster. It makes it quicker. It makes it valid, and that is part of the advantages of having a will. It also helps you to minimize estate taxes. Writing a will minimize the tax you probably will pay if you have to, go through the hassles of letting your beneficiaries or your loved ones to process letter of administration after your demise. This is part of the advantages of having a will. It helps you to, minimize estate taxes that you are going to be paying. Another advantage of having a will done is that it helps you to know who will administer your estate. In a will, there's usually a column where you will appoint executors, people who will execute that will you have put in place. Executors will make sure that your will is done and giving of assets is done just as you have wished and you have written down. So it helps you to determine that this is the person that I want to take charge to administer my estate after my demise. You would have appointed the person in your will. So that's part of the advantages of having a will done. Also, a will help you to disinherit individuals that you do not want to receive your property. There are people you probably think, I don't want to give this thing I don't want to give my property to this person. If you don't have a will done, of course, letter of administration the administrator will probably give some things to that person that you want to disinherit. But your will have stated it. I do not want this person to inherit any of my estate. And that's also part of the advantages of having your wills done. Then wills help you to make gifts and donations. It's not only your family members now that may benefit from your estate if you have a will done. You can put in place that you want to make gifts of so amount, or a house or property, any of your estate to a particular person, either charity, your friend, your loved ones, or anybody you feel you want to help. It makes you to be able to make gifts and donations. So in addition to distributing your estate to your family members now, a will also allows you to make donations to your favorite charitable causes. This is especially beneficial because gifts up to certain amount may also reduce your tax liability. So when drafting your will, check for the most up-to-date gift tax exclusion. If you do not have a will, intestate laws do not provide for charitable donations. So it's always good if you know that you have people that you want to donate to, or you have some charitable causes that you want to advance. It's always better and advisable to have your will up to date, to have your will done. And of course, having a will can also help you to always update your will. So people will ask questions like, okay, what if I've written this will now and I didn't die in 10 years, 15 years, and I've acquired other properties? Of course, there's a way you can update your will. We call it codicil. Codicil is a document that helps you to update that will you have written. You understand? When you have a codicil, it's like a supplement or an addition to your will that you have written. Doesn't necessarily dispose your will that you have written. It only explains it, modifies it, qualifies it, and add to it. So you can also add to whatever you have acquired after you have made your will by having a codicil. So there are a lot of advantages attached to having your will done. Also, wills will help you to avoid legal challenges. You have seen cases where after a particular person dies, the family members goes ahead, obtain letter of administrations. There'll be rancor in the family. Some people will be like, you're not supposed to be a beneficiary. You're not supposed to have these. There will be legal issues after your demise. You don't want that. You don't want to leave a family that is full of rancor. So it's better to have your wills done. You will have stated who gets what, who gets this, who gets that. It will avoid legal challenges for the loved ones that you leave behind. And we all know that tomorrow is not promised. Tomorrow is not promised. A will is an important document that is the cornerstone of your estate plan. You do not let procrastination get the best of you. If you want to write your will, do it now. Don't procrastinate on it. Once you pass away, that is once you die, the opportunity to make a will is gone. So prevent additional grief for your family members during an already emotional time by drafting a will for them. When you die, they're already in that emotional state. Having to apply for a letter of administration and everything could be draining for them emotionally. So you should help them out. They're already in a grieving time, so prevent additional grief for them by making your will. That will help you a lot. Now, before you can say that a will is valid, there are some things that must be present before you can say that that will is valid. Don't just say, okay, I've written my will. I've written my will. So part of the things that must be present in writing your will is that will must be in writing. You can't just say that, okay, I know what I want to give to the beneficiaries of my estate. I called somebody, I've whispered it to the person. How will the person prove it? So it's always better to have your will in writing. That is part of the requirement for a valid will. Having your will in writing. Then again, that will must be signed by you, who is a testator, before we can say that is a valid will. It must be signed. It must also be witnessed. You will have witnesses signing to it. You can't sign it out of a truth. This person made this will. So apart from that, another thing is that the testator that makes that will or that signs it must acknowledge that signature in the presence of two witnesses. Like I said, it's not only for you to provide column for witnesses. You must acknowledge it. You must sign in the presence of these two witnesses. That is the provision of the law. And these two witnesses also will attest and subscribe to the will in the presence of the testator. That is to show that this will is indeed valid. Another requirement for a valid will is that the testator must possess what we call testamentary capacity. And what do you mean by testamentary capacity? It must be of sound mind. At the time the person is making that will, the person must be of sound mind. He must know that I know this is my property. I know I have the capacity and capability to understand that this is my properties. I understand that I want to give my properties out. I understand the people I am giving it to. I understand the people I do not want to give to. I understand the people I have appointed to be executors of my will. That means he must be of sound mind, must be able to understand what he is doing at that particular time that he's making that will. So those are just the requirements that your will must possess before we can say that it's a valid will. It must be in writing. You must sign it as a testator in the presence of two witnesses. The two witnesses must also attest to it in the presence of the testator. The testator must, of course, have testamentary capacity. Those are the requirements of a valid will. Those are the things your will must possess before we can say that you have a valid will already written. Now, I've been mentioning executors. Some people will be wondering, well, who are the executors? Like I said, your will gives you the opportunity to name some people executors of your will. So simply put, who is an executor? Executor can be a person or can be an entity that you have appointed to administer your estate. Their primary responsibility is to distribute your estate assets just as you have, put it down, just as you intended it. They will make sure your beneficiaries get what you have given to them. In case when you die, they make sure that the wishes, the will of the testator is executed, is put in place. And that is just the work of the beneficiaries. And they have fiduciary duty to act in good faith and in the best interest of that estate and in the interest of the person who had written down or stated how you want his estate to be shared or to be administered after his demise. So now, do you even know that you can make your will by yourself? You can make your will by yourself. There are things you must know that you put in place if you're going to be writing it by yourself. I always say it on this program, it's always advisable to get a legal practitioner to do these things for you. It's always advisable now in this instance to get a legal practitioner to write your will for you, but you are not obligated to do that. If you want to write it by yourself, of course you have the right to write it by yourself, but you must make sure that some things are present. The first of it is that your full name and address must be there. You must be able to recognize that this is the will of this person writing this. We must be able to recognize that this is the address of the person writing it for identification purpose. So you must put your full name and your address in that way. If you want to write it for yourself, then you must put a declaration that you are of sound mind while you are writing that will. It shows that you have the testamentary capacity. You must put it, I'm of sound mind that at the time I'm writing this will. If you want to write it by yourself, then you will list your beneficiaries. You will list your beneficiaries and the share of inheritance that goes to each person. So those are the things that you will put when you're writing the will by yourself. Of course, you will also name your executors, the details of them, their names, their address, for proper identification. You will name your executors that are going to be the executors of your will. Then, of course, you will appoint guardians, if applicable to you. If you have minor children, your will also help you to appoint guardians to take care of your children while they are still minors after your demise. So you can put it there. If you have minor children, you will put your signature. Of course, you will put your date. You will put the 2 witnesses that will witness the will for you. So if you're going to be writing that your will by yourself, which of course is, we advise that you get a legal practitioner, a solicitor, to write it for you. But if you think you want to write it for yourself, go ahead and do that. Just make sure you put those things in place: your full name and address, the declaration that you are of sound mind while you're writing the will, the list of your beneficiaries and the share of inheritance you are giving to each of them, the details of the executors that will be administering your estate after your demise. You also we appoint guardians if need be. If you have minor children, you appoint guardians to take care of them when you are no more. You put your signature, you put date, you put 2 witnesses. So like we said earlier, a will, writing a will does not mean you have your death sentence, or it doesn't mean that you have just a little time to die. Putting your will in place does not mean that you are about to to die. So all these things are just things that should be put in place for you to know that death is inevitable, and it's always good to put your house in order before you die. It's always good to put your family members in a clean state before you die. Don't add to their grief by making them have to start running around looking for the ways of applying for letter of administration, where you can just save them that hassle when they're already grieving. So writing a will is very important. It is very, very important. It's like a thoughtful and responsible way of ensuring that your loved ones are well taken care of after your demise. So don't make that mistake of thinking that only old people should write their will. Don't make that mistake of thinking that you should only write your will at your dying state, or that bed, or that your deathbed. You might not have the opportunity to write it at that particular time. You might not have the opportunity to write it at that bedridden state. You might not have the opportunity to write it at that dying state. It's always good to prepare ahead and make sure that you save your family members the problem or the grief, adding to their grief after you might have died. So a major benefit of making your will is that it establishes that you have a valid way of administering your estate, and it makes probate processes very easy. It makes you distribute your estate as you wish. It makes you disinherit anyone who you don't want to inherit your property. You just put things in order before you die. So these are the things you need to know about writing a will. And of course, next time we're going to bring you another exciting topic on legal clues on Emirate Radio. Please follow our platforms, all our social media platforms: TikTok, Facebook, Instagram, X, and of course Emirate Radio. Until next week, when we bring another juicy and interesting legal topic, please stay blessed. God bless you all.